Welcome back. Well, yes, indeed, much as there are those who now think that this opinion of the court, albeit a judgment, has thrown up different dynamics to this whole matter, pending when they determine the cases in court, which they expect to be consolidated in March. But let's even revisit some of the circumstances that precedes this particular judgment between the executive and the Senate, wherein the nominee or appointee of the president to head that position of EFCC gets to the Senate. Senate declines confirmation, and perhaps executive thinks, okay, well, let's even look through the law. If there isn't any specifics, if the law did not specifically speak about how many times the executive can present or represent an appointee that has been rejected by the Senate, can they keep representing him to the Senate? When can an end be of that representation?
Well, as you have rightly observed, there appears to be no limit on the number of times an appointee whose appointment is subject to confirmation can be presented to the Senate. But what you must understand is that if the facts that was before the Senate, or if the fact that influenced the rejection of that appointee remains unchanged, frankly, I see no reason why the rejection will not stand.
But who determines if it's unchanged? Because if Senate thinks we don't have fresh facts, but what if, remember they had, what's the name of that panel again, that they set up to look into some of those cases, and they said they had fresh information. And so if on that basis, the executive thinks, yes, we have fresh information, and that the Senate is not privy to it, and the Senate says, no, we've gone through our process, we stand on our grounds, what happens?
Well, so far as the provision, the strict provisions of the law is concerned, the prerogative of confirming an appointment, so far as that of the Senate has an absolute discretion in how it goes about confirming any appointee whose appointment is subject to confirmation. But I think the very use of the word rejection, once an appointee is rejected, then for me that terminates the appointment of that person. Particularly when you bear in mind that the Interpretation Act in Section 11 says the power to appoint includes the power to suspend or remove, or to appoint somebody in an acting capacity. So that power of appointment also includes the power of appointing somebody in an acting capacity. Yeah. And that acting in an acting capacity is subject to the exact same limitations that applies to the power of appointment. In other words, you cannot appoint somebody in an acting capacity without confirmation from the Senate. Once you read Section 11 of the Interpretation Act with any provisions of any act, you must get Senate confirmation to appoint anybody in an acting capacity.
So,
okay, go ahead.
Sorry to jump in.
Yes.
Can we assume then, or if we assume that from that judgment for Justice John Soho, the power for the EFCC chairman to be, they have a joint role in terms of the executive and the Senate.
Yes.
Now, if they have a joint role in that appointment and that confirmation, do they have a joint role in removal?
Of course they do. The role is joint. In fact, from the judgment of Justice Soho, what he said is that the president's power of appointment is subservient to the Senate's power to confirm. From the phrase subject to, the president shall appoint the chairman of the EFCC, subject to. So it has made that power of appointment subservient to the power of confirmation.
So if the president appoints, Senate confirms, the president cannot remove without Senate approving that
without
removal.
Senate approving the removal. These are the clear effects of Section 11 of the Interpretation Act. And that is why it is not correct to assume that immediately the Senate has rejected somebody, the person can continue to act in that. The person ought to vacate that office. He cannot act because the power to act itself is subject to the self-same limitations that apply to the power of appointment.
So if you say it is illegal for the continued stay in acting capacity of the EFCC chairman, yes, Magu, what then would you say of a situation?
What I would say, I would just say there is no legal foundation for his occupying that office. He cannot point to any law that justifies his continued stay in that office.
Because
Certainly not the EFCC Act, certainly not the public service rules.
No, what about the powers that confer what about the law that confers the power of appointment on the president? And then those
Of certain offices, not every office.
There are those who argue that the president can appoint in acting capacity over and over and over again for as long as he wishes.
That is what I have said, that there is no law that backs up that statement that he can have. You see, power of appointment is one that must be backed up by law, either the Constitution or an act of the National Assembly. Show me where in the EFCC Act that says you can appoint the EFCC chairman in acting capacity over and over and over again. Or show me where in the Constitution that says the president can appoint somebody in acting capacity over and over and again. It's not there. And the offices in Section 171 are specified. And if you look very closely at those are offices that are more akin to the civil service of the Federation.
Not the public service.
Not the public service.
So
when you
in this
look at
case,
the officer as secretary to the government of the Federation, head of the civil service, permanent secretaries or heads of extra... You see, if you look at the definition of civil service under Section 318, it's pretty clear that these offices referred to in Section 1 pertain more to the civil service of the... and not the public service.
Okay, even though I'd like to go back to how you started, this is just the opinion of the court.
Yes.
It was struck out, no locus.
No locus standing.
They can't go ahead and thumb their chest on this and say, well, we'll have a judgment. I'm not sure that can be the case.
I don't think so either.
All right, Mr. Robert Emekwero, a legal practitioner, thank you for coming on this morning.
Thank you so very much for having me.
So I'm sure that maybe by March, the nation will witness another round of debate on this matter. Mark,